Well, my husband, or I'm sorry, ex-husband, we have a mutually beneficial agreement with our children where he keeps them at night and I keep them during the day.
Okay.
But my job no longer allows me to stay home with them during the day, and I would like for them to go to daycare now during the day, and he does not want them to.
Okay. How old are the children?
2 years and 18 months.
Okay. And you already picked out the daycare you want them to go to and everything like
Yes.
that? How much is it?
It is $500 a month.
$500 for both children?
For one child. So it's $1,000 a month for both children.
Oh, okay.
It's a nationally accredited daycare.
Okay.
Welcome back to Judge Bench, where real family courtroom drama comes to life. Today, we're diving into a compelling case from Support Court that highlights the real-world struggles of co-parenting, personal responsibility, and what's truly in the best interest of the children. Be sure to subscribe to Judge Bench and turn on your notifications so you never miss a case breakdown like this one. The court is called into session for case number JBB 1009, Moore versus Davis. The judge greets the courtroom and invites everyone to be seated. Ms. Moore, the mother, has brought the case forward. She explains that she and her ex-husband have a mutually beneficial parenting agreement. He cares for the children at night, while she watches them during the day. However, due to a recent change in her job, Ms. Moore can no longer stay home with the children during the day, prompting her to seek a modification to their current arrangement.
Yeah, I was invited, but I don't really want my kids in that daycare. I don't want to be in that
What's
daycare.
wrong with the daycare?
They're full of germs. For starters,
this courtroom is full of germs.
Okay, but children germs, they're next level.
Okay, do they disinfect the daycare?
I don't know that.
They do.
Right, you don't know. So you haven't even had the opportunity, you haven't taken the opportunity to try to do any kind of research.
Okay.
But the fact that there are germs at the daycare, I mean, that's not a good enough reason why you don't want them in there.
I would rather them be with family, people we know.
Okay.
Ms. Moore explains that one of the reasons the marriage didn't work was because Mr. Davis is an extreme germaphobe. She accuses him of trying to shelter their children in a bubble, which she believes is neither realistic nor healthy. She emphasizes that she has a demanding job saving lives and needs a reliable and consistent solution for childcare. Ms. Moore also criticizes Mr. Davis for refusing to tour the daycare or meet the staff, an experience she believes their children would have enjoyed. In response, the judge urges Mr. Davis to at least visit the daycare, speak with the teachers, and assess the facility's cleanliness before outright dismissing it. More importantly, the judge reminds both parents that they must work together and prioritize co-parenting for the well-being of their children.
Okay, look, with all due respect, I don't even want to be in this courtroom, Your Honor.
I can understand that. Sometimes I don't want to be here.
I don't want to be here.
So, I mean,
but I'm here. I'm here for the kids, and I would prefer if they weren't in a daycare, if they were at one of our family members, where we can give them special instructions on cleaning and what the children need to stay healthy.
well, I definitely understand, and I agree. In a lot of cases, it is good for the children to be around a family member and everything like that.
Given that the parents already have an existing agreement that benefits both parties, especially in terms of finances, the judge affirms that the shared custody arrangement will remain in place and that neither party will be ordered to pay child support. However, to ensure that daycare expenses are consistently covered, the judge rules that both parents must split the $1,000 monthly daycare bill, $500 each, through the Texas Attorney General's office. This creates a formal system to guarantee timely payment. Mr. Davis objects, arguing that he's being required to pay for a daycare he doesn't support during hours when Ms. Moore is supposed to be responsible for the children. He insists that if the expense were related to nighttime care, which falls under his responsibility, he would be willing to cover the cost.
And you guys should just work together and co-parent. So the agreement is just going to stand what it is. You guys keep doing your agreement where you have your time with the children, and you keep rotating like that, nobody should pay child support in this type of situation. But what I will do to make sure that daycare does get paid is that you guys split it. So $1,000, you pay $500, you pay $500, and it's going to go through the Attorney General of Texas. And that's just the best way to do it, because that at least ensures that the children's daycare is paid for month to month.
Mr. Davis argues that the 50-50 split is unfair, since Ms. Moore earns 3 times more than he does. However, the judge reminds him that the $1,000 daycare cost is reasonable for 2 young children, and that shared parenting means shared expenses. She adds that if child support were calculated based on his $62,000 annual income, he'd owe more than $500 a month. When asked if he wants support calculated that way, Mr. Davis quickly declines.
Okay, but now I'm paying for the daycare that I don't want them to go to, and I have them at night. She's supposed to be responsible for the day. If they were in night care, I would pay for it, and I just don't see how this is fair. She makes 3 times as much money as I do.
Right, but you guys have been splitting the children, right? You've been splitting the children, and it's not a bad idea. And honestly, that's a very reasonable cost for 2 children at a daycare, because a lot of times, especially the younger a child is, the 18-month-old, it could be more expensive than that. And I think that's fair. Or, I could base, let me see, how much money you make a year? Let's see. Your document says $62,000?
Yes, ma'am.
Would you like for me to base child support that you pay her off of $62,000 a year? Because I can assure you it will be more than $500.
Then no.
Okay, well.
After dismissing the court, a quick recap highlights the key points. This case was unique because no child support was ordered, as both parents share custody. The father's dislike of daycare due to germ concerns wasn't enough to override the mother's need for childcare. In the end, the court focused on the children's needs, not the parents' disagreements. If you've faced a similar situation, share your story in the comments. It might inspire a future episode. And don't forget to subscribe to Judge Bench, where real courtroom drama is not just served but explained.